Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. Today, I'm joined with my colleague, who is a shareholder at Retzel and Andrus, as well as a member of our litigation group. And this is Mike Scotty. Thanks so much for joining me.
Hey, happy to be here, Erica.
So today we're going to talk about a topic that has become very hot for our clients lately. And this has to do with basically extortion claims that patients bring against our clients, either threatening to leave negative reviews, which is leads to us to talk about defamation, which we're going to cover, or threatening to sue in a malpractice claim, or threatening to alert the Illinois Department of Financial Professional Regulation or another state board or government agency about something that they believe or are willing to argue that the physician or dentist or other healthcare provider has done. Now, typically, when these situations arise, it is done in an effort to receive free services or to get a refund on services that were provided. Also, typically, our clients do not believe that they have done anything wrong, but they are scared and anxious about either having to deal with a negative review, something that could hurt their reputation, or having to go through a malpractice claim situation or a visit by a government entity to prove that they did nothing wrong. So this is quite a hot topic, and I know, Mike, you're going to have quite a lot to share with us. So why don't we break this down a little bit and start with what should you do if somebody threatens to leave a negative review for you if you don't either do something for free or refund some amount?
Okay. Well, Erica, as you know, and as your audience knows, nowadays anybody with a mobile phone or a computer laptop has a public voice. There are social media options like Facebook. Many providers have Google pages in which they have Google reviews, actually inviting reviews. And so when a healthcare professional faces a patient that is unhappy with services or is trying to gain free services uh, by threatening a bad review, I mean, that's essentially extortion. Now, that's a crime in Illinois. Now, realistically, if you report this to somebody, nobody's going to actually follow up on the crime. So most of these things are actually dealt with by the professional. And, what I would recommend people to do is to first off, stay professional. Don't get emotional about this. Try to understand if there's any legitimacy to their complaint. And if there is, address it on the merits. If they are making false statements or threatening to make false statements, uh, do everything you can to record or memorialize the exchanges, whether it's through text or email or a personal conversation. And so you have evidence of these things. And then if they, but you should engage these people to try to avoid the posting altogether. And it also depends on the forum. For example, I would encourage professionals who have Google review pages. If these things are placed on your Google page, you can report it and ask for it to be stricken. And there are several categories that the Google staff will review it for: falsity, abusive, extortion, things like that. You can get them reviewed there. If you have a Facebook page where these are posted, I would set your settings so that you have the opportunity to review the reviews before they are published. But there are many environments where you can't control it. And in those, you know, after the post has been made, you have very few options, right? Because you can send a cease and desist letter, or you can ask them to take it down under the threat of litigation. Um, if you're trying to, if you catch it soon enough and you're able to negotiate something where they agree not to do this, it's important that you confirm that in writing with some type of a release language. In those instances, whether you are paying money or refunding money, I would make sure that you have a written release that includes what, non-disparagement agreement, where they agree not to disparage you publicly. And disparagement, as you probably know, is much broader than defamation. It's just a derogatory comment at all. Um, so these are some of the things that I would recommend for professionals to do.
Okay, great. And just a reminder to those listening that responding to the comment that a patient makes on a Facebook or other type of social media page is not something you can do without putting HIPAA violation at risk. So, that's why Mike has recommended other approaches. At a minimum, if you feel you must respond, you could say, we invite you to contact our office to discuss any concerns you may have without acknowledging if that person is a patient and without responding to their comments whatsoever. So just want to remind people who may not, remember that to comply with HIPAA at all times.
And Erica, HIPAA's not my area, but just in strict risk management, can the doctor or the dentist or healthcare provider just make a statement that we disagree with these statements, and invite the patient to follow up to and engage in a further conversation about their dispute?
I usually recommend just a global, anyone with concerns can call our office. The problem is that even acknowledging that someone is a patient itself could be a HIPAA violation. So that's why these kind of social comments online really tie a doctor's hands in a way that it doesn't tie anybody else's hands out there. The doctor is literally silenced by HIPAA in terms of being able to defend their reputation and stand up for themselves. It's a very difficult position to be in.
Yeah. Well, I would imagine that, and again, I'm not knowledgeable on the HIPAA laws, but if somebody prints something about you where they have a bad opinion, that's one thing. But if they make a false statement, you can send a cease and desist letter. And if they don't take their post down, then you can sue them for defamation. Now,
Correct.
Of course, the provider has to take into account, litigation costs to bring such a claim. But if you were aggressive about that, sometimes that aggression can prevent other people from making negative comments.
Correct. And we've been successful in tracking down anonymous posters who have posted false information on our doctor sites. We can use the court system quite effectively to force a retraction or force a settlement. So that's something that you and your team have definitely done. It's not easy, but a lot of people, do find it worthwhile. And there are steps that can be taken. So the one thing I'll point out is sometimes people will call me and say, I know it's this person who's posting. I know it's that person. I want you to send them a cease and desist. And unfortunately, we can't assume that, just because we think we know who it is, that we can start sending out legal letters. And so that's a situation I think happens quite often.
Yeah, for sure. And, the legal route, you could probably, if you filed a defamation suit, you could respond online that say, we strongly disagree with the statement. And as a matter of fact, we filed a defamation case against the author, and you could put a link to the complaint. And that would also be a warning to others from making false statements.
Right. I'm sure we could do something. Well, that's never happened before, but it's definitely something to consider, right? So, all right, so let's talk about a situation then where somebody is saying, hey, I'm going to sue you for malpractice unless you give me my money back, or you do XYZ. And in obviously where it's a true bad outcome and there's potential malpractice risk, and even if there's not, we always recommend you can call a hotline for your malpractice carrier, because certainly the word malpractice should trigger you to talk to your carrier. But some patients seem to be using this as a strategy. And so, what can a professional consider doing when they're being extorted in this way?
Well, if it's pure extortion, if there are false claims where they're demanding money, you could make a police report. But again, historically, the police aren't going to follow up on that. You would, of course, like you said, report it to your malpractice carrier. I would strongly encourage the person who's in this situation to contact their lawyer to get some advice, because all these situations are a little bit different. But at the end of the day, your choices are essentially threefold. You either A, you work out a deal with them where you pay them to go away and you get a release and a non-disparagement agreement. B, you ignore them, or C, you sue them and for harassment and and defamation. You really have three options, and you know, sometimes the least expensive one is paying them to go away, but then you encourage this type of conduct in the future. And while the most expensive, at least to your pocketbook, is filing a lawsuit, that can be incredibly effective at calling them out. Whereas if somebody's alleging malpractice, they've got to go find a lawyer who's willing to represent them on that claim, and they have to pay a lawyer to defend them in a defamation or an extortion claim. And so it can be very expensive for the individual bringing the threat.
Right. Yeah. And by the way, if you do reach a settlement with a patient, the next step, which I'm always surprised people forget, is that that patient should be terminated from your practice as well. Any number of times, we reach settlements and then the doctor doesn't do that and the patient comes back a couple weeks later, a couple months later, makes an appointment for services. So just as to close the loop on that, please make sure that if a patient has done this before, that you are no longer rendering services to them. Of course, you also want to be careful not to disparage them as well. Meaning, if somebody calls you up and say, hey, John Smith used to be a patient in your practice, do you have any idea why he left and now he comes here? Of course, you don't want to say, he's a liar, he's a thief, he extorted me, just say, obviously there may be confidentiality provisions anyways in an agreement that's signed, but just try and remember that. So these are things that non-legal minds don't think about, which is why I'm mentioning them. You'll find yourself receiving a letter instead, right?
That's right. And in these release agreements, not only have I seen non-disparagement agreements, which are pretty common, but also an agreement like an agreement not to seek further services from the office. So they have to agree that that's the last time they're going to contact this office ever again. And so you can also put that in your release if you work out a deal.
All right. Good thoughts. So the final category that I have recently seen happen is a threat of making a complaint to the state licensing board or someone else. And, I know you don't specifically deal with the licensing board, but I think it's important for everyone to understand that they're under an obligation to investigate every claim that's made. So if in fact you've done what Mike suggested and you've kept a record of the emails and the threats that you've received, that's going to be the first thing that you turn over. Okay. Obviously, you get the opportunity to respond, explain what occurred, and the events. Now, if something really did happen that rises to the level of investigation, then you're going to have to deal with it, right? But certainly, you should consider the steps that Mike has suggested if that's not the case. And most importantly, anything related to your license, you should be talking with counsel before you go through that process. Oh, and
Yeah.
I'll also mention your malpractice carrier might actually cover that and cover the legal fees related to such a claim also, by the way. So,
You know, like you said, Eric, I don't have a lot of experience with physicians' professional obligations to the state, but would is there an ethics about dissuading a patient from making a complaint? I know that in the legal field, people make complaints to the ARDC, and it's against public policy to make a deal that prohibits them from making a complaint against you. And I don't know if the same thing applies to physicians.
no, I mean, I'm not aware of that. Obviously, a doctor hasn't his ethical or her ethical obligation. But certainly, I think what you're suggesting is paying someone off not to file a complaint. I would guess there probably are some ethical guidelines out there, at least put out by the AMA, if not by an actual specialty board.
Yeah.
But I think, the scenario I'm imagining here are people making things up to extort. So where there is legitimacy, I certainly wouldn't recommend paying someone off. I think reaching a mutual settlement might be a different way to to maybe address that. But literally where you're just being extorted and there's no validity, or you truly reasonably believe there is none, I think you would be okay to reach an understanding. So,
Very good.
all right. So this is a pretty hot topic. I'm hoping the people seeing it who have faced the situation or may face it, it is really a growing area, particularly the online piece of it, will remember to think about what we've talked about and to seek some legal guidance. Please feel free to reach out to Mike. He is leading our team, particularly on these kinds of non-disparagement type situation, these online postings, which I think you would agree are growing in number.
Yeah, it's growing exponentially. The whole field of defamation and disparagement is growing dramatically, as you see in the news every day.
Okay, great. So Mike's your guy. If you have any questions and you need some expertise in this area, please feel free to reach out. We'll be sharing, of course, his information when we post this. And as always, thanks for joining us on the Health Law Hotspot. We'll catch you next time, and you can see our other topics at ralaw.com. Thanks for being here.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.